when I look at SCR 20:1.16 that deals with declining or terminating representation, there is a section of that under a little bit kind of odd how it's numbered, but there's a small a at the beginning, and then subs 1, 2, 3, and then under 3 there's in parentheses a B, which I believe is the provision for which both.
Whoa, pump the brakes. We're diving headfirst into legal jargon, but here's the deal. This judge is quoting ethics rule SCR 21:16 like it's gospel. Translation: lawyers can jump ship if continuing the case could hurt the client, or if things get ethically messy. And guess what? It sounds like we're knee-deep in messy.
Both of you are seeking to withdraw, that states, except as stated in paragraph sub C, a lawyer may withdraw from representing a client if 1. Withdrawal can be accomplished without material adverse effect on the interest of the client. 2. The client persists in a course of action involving the lawyer's services that the lawyer reasonably believes is criminal or fraudulent. 3. The client has used the lawyer's services to perpetuate a crime or fraud. 4. The client insists upon taking action that the lawyer considers repugnant or with which the lawyer has a fundamental disagreement. And if you look further down, there's an or. So it's not that all of these things need to be shown, it's an or. I mean, I don't have the benefit of knowing the basis for what you think is the conflict, other than there's this letter, it says not so nice things, but that's all. I have a denial, apparently, at least what the state is saying, that your client denies writing this. I mean, I could come up with a lot of scenarios where, obviously many people watch this trial. Anyone could take notes. I took time looking through all of this filing, and I think there might be some circumstantial evidence, if you will, that perhaps Jesse Kershevsky is the author. There's content, there are the trial notes, there's other things, but I don't know that anyone can definitively say that.
Okay, this is where things get juicy. The judge basically says, hey, someone might have written a shady letter, but who? There's handwriting, trial notes, mystery authorship, and a hint of fraud. It's like Legal Clue, except Colonel Mustard might be your defense counsel.
At this point in time, I don't even know if I should even consider this. I mean, that's one of the things. If I simply say, I'm striking this from the record, I will not consider it based upon the uncertainty and the ongoing investigation, how is there any conflict of interest?
May I speak?
No, not yet. You are still represented by counsel, and you need
Judge,
to
that's what I
talk to
want to
them
speak
first.
about.
No, hold on.
Judge, some of those papers in there have our handwritten notes on them. We know our own writing.
Well, I don't know that, do I?
But I'm telling you now.
But see, that's where an affidavit would have been really, really helpful. Could have been filed under seal. Could have given me more information and avoid what I'm doing here in court on the record.
Understood. We recognize some of our own notes from trial.
All right, so you believe at least a part of that filing that has what appear to be trial notes were contemporaneously done during the trial, and you recognize your own handwriting on some of it.
Yes.
All right. I've taken a look at also the confidentiality requirements that are applicable to both of you. There are some limited exceptions to what I would term as the confidentiality requirements between an attorney and a client.
Heads up, legal nerds. This is where confidentiality meets complication. The judge is threading the needle between client-attorney privilege and an attorney's duty to prevent fraud. It's the kind of legal tightrope that could cost someone their license or their freedom.
Some fall under a shall and some fall under a may. And even if I look under, and it's the SCR 20:1.6, says sub C, a lawyer may reveal information relating to the representation of a client to the extent the lawyer reasonably believes necessary. Sub 1 does not apply. There's not death or substantial bodily harm that you would be preventing. You wouldn't be preventing, mitigating, or rectifying substantial injury to another person. But here's where I think you could potentially be required, or at least asked to reveal, when it would be to prevent, mitigate, or rectify substantial injury to the financial interest or property of another that is reasonably certain to result or has resulted from the client's commission of a crime or fraud in furtherance of which the client has used the lawyer's services. Even if you believe there's some unwitting use of your services, the fact that part of these crimes for which your client now stands convicted involves theft from the estate and there's a pending probate case, I think one could argue that what's in this letter, if true, I think for purposes of the motion, I have to assume that it's true. I don't think I kind of give you all the benefit. It's just for purposes of the withdrawal, Mr. Krzyzewski, right? Your attorneys have asked to withdraw. I have to base it on some facts. And hold on.
I haven't had representation in the last week though, and I need to be able to speak to
Mr.
that.
Krzyzewski, now's not the time. You will be given an opportunity, but I need to have facts upon which this decision of mine, which is a very important decision, be made. Counsel and defendants oftentimes have a disagreement on strategy. Relationships fall apart. That does not always mean that attorneys are allowed to withdraw, because as Attorney Sitzberger has pointed out, it would be so simple and it'd lead to absurd results if every time a defendant raised an allegation, whether it be an ethics complaint or criminal activity, if that were enough, we'd never have criminal.
Oof. You can feel the judge's frustration here. And she's right. If every defendant could swap lawyers by claiming foul play, courtrooms would be chaos. But what if there really is a conflict? That's the tightrope. Justice versus delay.
Defense attorneys, right? So there has to be something more. I'm concerned in this case because of the fact there's not a postmark on this envelope. And I'm concerned that there is an ongoing investigation as to whether it came from the jail, whether it came from you or someone else. There's other things it could be. Like I said, there's, a lot of people watch the trial. I now know that your attorneys recognize their own handwriting. That's very concerning to the court because very few people would have had access to that. And I have to be concerned with the integrity of these. I read the cases that the defense cited, and in particular, State versus Miller. There's a difference when ineffective assistance of counsel and a conflict of interest is raised in a post-conviction proceeding, and what a defendant or an attorney, or even in the Miller case, there's a discussion of when the state raises a concern with counsel. And that in that circumstance, which is really not what we're dealing with here, that it can't just be fabricated to get counsel off of a case when there's an adversary that the state might think is formidable. That's what it's talked about in that case. But this is raised prior to sentencing. And I believe the case law is pretty darn clear that if I can find there's an actual conflict of interest or a serious potential conflict of interest, then I have to presume there's prejudice. That means I create a situation, if I make all those findings, that cast doubt on the entire sentencing hearing if I force attorneys Kukler and Galavis to stay on. That's what we're dealing with right here. And for everyone, the court now, I'm right here with everyone. Is it frustrating? Absolutely. Do I want to get this case concluded? Absolutely. Do I want to give Ms. Kershevsky the opportunity to file her appeal, which presumably will follow and raise issues? Absolutely. I'm well aware there's rulings you will absolutely want to appeal that I made. One of which is the jury instructions. I get that. And for the victim, there needs to be finality as well. But it does no one any good if I ignore all of this, simply plow forward, and then have to redo it at a later point in time. I'm a big believer, right? Let's do things right the first time to avoid that appeal, or at least that particular issue. And I think there's an argument that if I ignore all of this and later on a court of appeals or Supreme Court says this was an actual conflict of interest, or one at least that rises to the level of being a serious potential conflict of interest.
This part is courtroom heartbreak. The judge is clearly torn. She wants closure for the victim, a clean appeal path for the defendant, and to not redo the whole circus down the line. But justice isn't speedrunning. It's getting it right the first time.
Then that's that would likely be the remedy, assuming all other issues, would be affirmed. So I'm mindful of that as well. This weighs heavily on me. I spent a lot of time looking at it. I looked at the various ethical provisions. And while I agree with the state that it can't be just an allegation from a disgruntled or desperate defendant, generally speaking, there has to be something more. It is important, Ms. Kershevsky, that I know your position on all of this as well, because also in the case law, there's a recognition that even with an appointed attorney, if this is who you want to continue representation, that matters as well. And I don't know your position, so I'll ask you. I don't want you to comment on anything else. Merely, do you want either Attorney Galavis or Attorney Kugler to represent you at sentencing?
I did. I do not, because up until yesterday, neither one has done anything for me now because they had halted all proceedings due to the DA conversation they have had. So at this point, as much as I wanted to get out of Waukesha County and proceed forward and go through appeals, I don't, because nothing has been done for sentencing except last minute yesterday. Partial. I have letters of character in limbo. I have nothing completed for sentencing, so no, I don't, and I frankly blame the state for that. They proceeded to release this information, which should have not been done, and it has created this mess. So while they are requesting they should not withdraw on their behalf, I don't think this is right. Everything has been done wrong since they have came forward last week with this information. And I do say, no, I did not write it. There's cameras all over this jail. There's recorded phone calls. There's a lot of issues here that, no, everything should be stopped. And I need to look at my legal rights because I don't know what they are at this point.
I can tell you.
No, I do not think because of everything that I have since learned, no, I should not have either attorney, which is very hard, proceed at this point, and sentencing should be stopped today.
I can advise you that even if I require them to stay on, I would not go forward with sentencing today because I'm mindful that there's been a pause. And so knowing that if I were to keep them on, I would adjourn sentencing to give them time to prepare. Does that change your position in any way?
No, I don't think either one of them feel comfortable staying on, so I would prefer not to at this point because of the conversation or little of conversation I've had with both of them. I would prefer not to, no.
Do you understand that could be a significant delay?
Unfortunately, yes, I do. And that is more upsetting, and that is on the state at this point. They released this information. They made this mess. It should have been stopped, but they did this. And that is, quite frankly, very frustrating. And they have no way to blame but themselves right now. And it is very frustrating. It is very frustrating. And I was told walking out of the detective's office last week, just so you know, you probably will not be leaving anytime soon because of this. Knowing I want to leave. I have not told them I did not write these letters. So again, that is coming from what? My phone calls? My conversations?
All right,
I did not.
We should,
I'm
going to advise you at this point that I've heard your position. You should consult with an attorney
I would love to. I still have on
before
record and nobody
making
will
any
talk to
further
me.
statements.
I've been trying all week. And I have a letter for you that I have tried to get through the jail, but I will not send it anywhere because I don't trust putting anything out there. So I've had a letter since Sunday for you. I couldn't send it. I have it with me today. Obviously,
I'll
don't
accept
have it
that
right now.
filing today if you would like to provide it. And it will be uploaded and e-filed and it will be part of the record.
That is completely fine.